Okay, Shannon, you can put us on the record. This is a matter of Hartle v. Hartle. Mr. Conan for the plaintiff, Mr. Navarre for the defense, and both parties are present. So we have a motion to change custody. Mr. Conan.
Thank you, Your Honor. Well, my client initially filed this on her own. It was initiated by her son, who wrote a letter that's attached to her petition. I've gone ahead and amended the petition. I think it really sets out what I consider to be pretty much emotional abuse. Father really not caring for these children. The minor child being called fat by his father. The father defaming the mother in front of the child. The child really had to try to protect his brother. Just a number of allegations, creating such a extreme environment that the kids don't. Dad, since this motion's been filed, hasn't made one effort to call either child or call mother to try to initiate any kind of a parenting time with him. I mean, this is just an ongoing abuse. I think that we're entitled to have an evidentiary hearing to put these facts before the court to show that that this is an unhealthy situation. Mom's got the boys in counseling right now, and is trying to deal with their emotional problems that have been created by being in dad's environment. And one of the major problems too is the fact that kids at 3 in the morning, these kids are falling asleep in school. This was probably not a good proposed order to begin with, but it certainly is not working successfully. We think that the best interest of the children and for their emotional well-being is to be placed with mom.
Navarre?
Just not true, Judge. Not true at all. The kids had been in counseling. They've been residing with dad since sometime in 2019. He's filed numerous parenting time denials with a friend of the court. Those are all set also to be heard this morning before Your Honor, based on communication that I received from the friend of the court. She's kept the boys away from their father. She voluntarily entered into a stipulated order in May of 2020, after the kids have been residing with dad on a full-time basis since sometime in 2019. Everything was going fine. We've attached school records to show that the boys only missed 5 days of school during that academic school year. They've missed, I think, 18 days of school. 18 days for Matthew, 17 days for Austin. And basically, yeah, she's stopped the counseling with the previous counselors and is seeking out, new counselors, even though this is a joint legal custodial decision. My client never agreed to terminate the former counselors, Mr. McComas, who's authored a letter that we've attached as an exhibit to our response. Also, Christine Hall Reed, who was treating Matthew. And that counseling stopped because she didn't see the need for it, to continue. As it relates to Doug McComas, that also stopped. There were a couple of sessions in March of this year. And then he was advised, and in his letter, he indicates that mother's going to seek counseling elsewhere. It was working just fine, Judge, about him getting up early in the morning. It's something that they agreed to. She was represented by counsel. I know that it's an unusual schedule. My client indicates that he's never had any communication from the school, even though he's been in contact with the school and with the teachers about the boys falling asleep in class. Numerous absences and, with mom on mom's time. Certainly my client denies any kind of allegations of abuse. It's just not true. So, I mean, it's our position that it's really thin. If you think it's necessary to set it for an evidentiary hearing to make a Von Barca threshold determination, that's up to your sound discretion. But Judge, my client has not seen his boys since the plaintiff here initiated this and refused to follow the court order. So we want her to follow the court order. That's what's in place now, and it should continue to be in place pending any evidentiary hearing if you think it's necessary to set one.
May I just briefly rebuttal, Your Honor? Both boys have their own telephone. They haven't gotten one phone call from Dad. Mom's got a phone. She hasn't gotten one phone call from Dad since the parenting time stopped. Dad hasn't made one trip over there to see the boys. He's real concerned, I'm sure, but he hasn't made any effort whatsoever. So he can file all the parenting time complaints he wants, but he's done nothing to show up to attempt to get the children, and he knows why, because he knows neither one of those boys would get in the car with him.
So, Mr. Navarre, I was looking for the counselor's letter. I'm not seeing it.
I don't.
Judge, I attached them as exhibits. They're exhibits number 2 and 3. They were dated May 16, Exhibit 2 from Christine Hall Reed, and Exhibit 3 dated, well, it's not dated, but that was authored this month by Doug McComas.
I don't have either of those exhibits.
I don't have your response or the exhibits. I was just looking to see if perhaps they had been scanned, but they haven't even been scanned. Let me see if at least they're entered on the docket.
Well, they were emailed to the clerk's office, Your Honor.
I'm not doubting you, Mr. Navarre. I'm just telling you I don't have them.
If you want to pass.
Is it possible for you to email that right now? I'd like to at least see what the counselor had to say.
Yes, Your Honor. If you give me it, you want me to send it to Peter?
Peter's no longer with us.
Okay.
John Fleming is my new law clerk.
Okay. Who would you like me to send it to, Judge?
You could send it directly to me.
Okay. Judge, if you give me just a moment, I'm going to open up another program just to make sure I've got your correct address.
If I could get a copy of it too, I'd like to be able to see what we're showing in court.
Yeah, I'll send that over to you, Dennis, and Judge, I'll send that over to you as well.
So has it been sent?
Your Honor, I've rescanned it to my server and it will be sent momentarily by my support staff. So if you want to, if you could put myself and a client in a breakout room while we're waiting, Judge, I'd be appreciative.
I can certainly do that.
Thank you, Judge.
Mr. Conant, as long as I'm creating a breakout room, would you like to speak with your client as well?
That'd be fine. Thank you.
Okay, folks, just follow the instructions on your screen. Okay, this is a matter of Brown versus Fletcher. See, we've got Mr. Hilderly for the plaintiff. Well, not quite. Waiting for a connection. All right. Mr. Hilderly is now with us. Ms. Fleming is here for the defendant. Looks like Ms. Fletcher is here by iPhone, and we're still waiting for Mr. Brown's device to connect. Looks like maybe that's happened. Mr. Brown, can you hear me? Not yet. Mr. Brown, if you can hear me, we cannot hear you. Check your audio settings. The fact that, well, there we go. I've got that little signal saying it's trying to connect. Mr. Brown? Mr. Hilderly, do you have his phone number handy? We've got the video, but we don't have audio. If I can get him on the phone, we can speed this along.
Oh, and of course, my notes with his number are not in this file. I apologize, Judge.
I might have it, Judge.
Hey, Ann, if you don't have it, let me know. I can pull it up real quick if you need it.
Yeah, if you have it, that'd be great, Melinda.
Yeah,
Thank you.
just 1 second. Hold on.
It's on your phone, right?
Yeah, yep. Okay. 517 917 8777.
Give that a try. Well, as often happens with this phone, the first time I dial a number, it doesn't go through. But the second time, it does.
Hello.
Hey, Mr. Brown, this is Judge LaFlamme. You could
Hi.
participate by phone. We could see you fine, but for whatever reason, we were having trouble with the audio connection. But now we're all present. Let's see. This is plaintiff's motion to modify parenting time. Go ahead, Mr. Hilderly.
Thank you, Your Honor. Brian Hilder appearing on behalf of Mr. Brown. We filed a motion to adjust the parenting time schedule. Both parties acknowledge that there's been a change to Ms. Fletcher's work schedule since the last hearing. The current order does provide that if there's a change in work schedule, that either party can come back to adjust the parenting time schedule as needed. Parties did go through a friend of the court mediation that was unsuccessful. Both parties agree that the schedule needs to be adjusted. They are both working essentially the same schedule right now, first shift. They both have Wednesday and Thursday off. So we're just trying to get the schedule adjusted at this point to account for the current work schedules. Child is 3 years old. He's not school aged yet. Miss Fletcher wants to do more of a 2-2-3 sort of a schedule. Mr. Brown would like to limit the number of exchanges. The parties don't necessarily get along wonderfully. He would like to limit the number of exchanges and do more of a week on, week off schedule. Miss Fletcher doesn't want to do it that way. So here we are for you to decide which way to go. The Miss Fletcher in her response indicates that there's some problems with the child during the exchanges. That to me would suggest that it might be a better idea to limit the number of exchanges rather than increase the number. Mr. Brown reports that there are no issues with his parenting time. Once his parenting time begins, there's no issues at all. He thinks that probably it's Miss Fletcher and what she does and says around these exchanges that is causing the problem, because once the child is with Mr. Brown, there's no issues whatsoever. The child did ask Mr. Brown the other day why he doesn't like mommy. Mr. Brown never discusses or disparages Miss Fletcher, so that's probably something the child is hearing from Miss Fletcher. So we just think that it would be a better schedule to do a week on, week off, limit the number of exchanges, and that's what we're asking the court to do.
So let me ask, it's unusual that two parents would have identical work schedules with identical days off. Do they both work at the same place?
Yes.
Corrections.
Okay. I figured that was probably the case. And how often do these schedules change? Is this a thing where you can bid on it, a different schedule once it becomes available? How does that work?
I think the days off in the shift, that they're locked into that for a while. What is an unknown, especially for my client, is whether or not she'll be mandated to work overtime. And unfortunately, the department is so understaffed that that is a rather common occurrence. And she doesn't really have any control over that. And that's been the bigger problem on her Tuesdays, is that if she's mandated to work overtime, she doesn't get out at 2:00. She might have to stay till 10 p.m.
And that's both parties are subject to that, Your Honor. That my client has that. And it's one of those things you would hope that the parties, given they're both in the same situation, would be accommodating with each other. Mr. Brown is willing to be accommodating, but it doesn't always get reciprocated.
Well,
So I'm assuming each party has some alternate care available if they're mandated to work
well,
when the child is with them.
Your Honor, I disagree with Mr. Hilderly's characterization that Mr. Brown is accommodating and it's not reciprocated. In fact, it's my client who communicates with Mr. Brown and gets no response. I find it enlightening that Mr. Hilderly reports that Isaac asks his daddy why he doesn't like his mommy. I don't think it's anything that his mother is saying. I think Isaac is smart enough to observe his father's behavior. Mr. Brown has other children. He has a child of similar age with his most recent ex-wife, and he has an older daughter with a woman from another relationship. And Isaac observes his father interact with those women, with those mothers, and with their children. Yet there's no interaction between Mr. Brown and Ms. Fletcher, and that's by Mr. Brown's choosing. My client does have arranged childcare. The issue that arises is if it's on an exchange date when they're mandated. The 2-2-3 schedule that I'm proposing, number one, is better for Isaac. He's still only 3. It would be difficult for him to go an entire week without either parent. But in our proposal, the party would be dropping off Isaac to the other parent or the other parent's child care provider at the beginning of the day. And then that makes the parent responsible for the day, for their child care, and there wouldn't have to be any communication or reliance on the other party. And then they would be responsible for their own child care. Oftentimes, Mr. Brown uses the mother of his older, or it's actually his middle daughter. He uses her for childcare. He watches Isaac and also the child they have in common. I think it would be a better situation right now. I'm not saying that at some point in the future that alternating weeks might not be more appropriate when Isaac is older, but currently I think the 2-2-3 would be better. And we're also requesting counseling to see if we can find out why Isaac runs and hides. And it's not just when he's around his mother. After having spent an entire day in childcare, when Mr. Brown goes to pick him up from Ms. Fletcher's daycare provider, the child hugs the daycare provider's leg. That's independent of any interaction or influence from my client. It's reported by the child care provider.
Your Honor,
So,
if I may
go
just
ahead,
add,
Mr. Cook.
and I'm glad Ms. Fleming pointed out Mr. Brown does have other children. He would like the schedule adjusted so that he can have all of his kids sort of together. I suppose if the court, and I don't know where the court falls on this, I know some judges feel that there's a sort of an age thing with week on, week off. We could do alternating Wednesdays with that week on, week off schedule, so that that week is broken up if the court feels that's a better solution. But the 2-2-3, we just feel like there's just too many exchanges, and it's part of what the problem is. So we could do it that way, where you alternate the Wednesday, so you don't have the full week. It's broken up by that day.
So what I was about to say, frankly, Mr. Hilderly, you predicted, which is with a child this long, I don't like to see the child go a whole week without seeing either parent. I don't think that's good. It's hard for the child, and it's also hard for the parent with a little one. I get that. As kids get older and they can adjust, particularly if there are difficulties with exchanges, the consistency of week on, week off has more appeal. Now, I say all this from the experience of a judge, not from the experience of a parent, because I've never experienced any of this myself. But from what I've heard over the years that I've been presiding over these cases, that is definitely my bent. So you're correct about that, Mr. Hilderly. Whether it's 223 or something else that works, what I'm likely to do is order something other than week on, week off that doesn't result in the child going a whole week without seeing either parent. With the unique challenges of their respective work schedules, this is a situation that cries out for a negotiated result. Knowing where my head is on that, I don't know if that's going to help at all. I know you tried to conciliate it. Ultimately, if you can't work it out, I don't have any choice but to schedule an evidentiary hearing, and then I'm going to do it. And what I do, neither one of them might like. So what I will do, I'll order an evidentiary hearing. Clearly, either parent is entitled to a hearing if work schedules change based on the order. I will order one. I would strongly encourage you to try to work this out. As far as counseling goes, we got a 3-year-old. Who counsels 3-year-olds? What do you tell them? I know sometimes they do a little bit of play therapy, but man, that's got to be challenging. Do we have somebody that specializes in that?
My best go-to resource would be a healing place, and I tend to think that they would involve the parents in that.
I certainly would value highly the opinion of a therapist as to whether or not it's going to be a waste of time with a 3-year-old. But if someone from the healing place says, yeah, we do it all the time, and we do have strategies for dealing with a child that's dealing with separation issues or whatever the issues are, that's my only hesitation is, can they really accomplish anything? This is really a situation that cries out for the parents to work really hard and put aside their dislike of each other and recognize that your child's going to do far, far much better, at least when he sees a positive relationship between the two of you. It's hard on a kid. So, I mean, a kid asking a question, why don't you like mommy, or why don't, it could be prompted by a number of things, but the most obvious one is they're not together. And it's hard on a kid when the parents aren't together, and they were, and now they're not. And now we're dealing with those kind of issues. But if you can get some feedback from a counselor that they actually have effective strategies for counseling a child of this age, certainly it would make sense that the parents be involved at some level. Whether they're there at the same time would be a different issue, but see what the counselor says. And then I would suggest, Ms. Fleming and Mr. Hilderly, that you share that information, talk about it. I'm reluctant to order counseling at this stage. I'll schedule the matter for an evidentiary hearing regarding parenting time. Dawn will get with you with a date. In the meantime, I would strongly encourage that you try to figure something out. Now that you know that I'm not going to do week on, week off purely, but I'm receptive to other alternatives that work with work schedules and make sure the kid doesn't go a whole week without seeing either parent.
Okay, thank you, Judge. I'll touch base with Ms. Fleming and see what we can work out.
And I'll check with the healing place.
All right, thank you.
Thanks,
Thank you.
Judge. Thanks, Melinda. I'll give you a call.
Have a good day, Mr. Brown.
Can I take this off the record, or do you want to?
I just sent a note for them to
Okay.
come back in.
Then I'll
So,
just pause.
yeah, let's.
Thank you, Judge.
All right, looks like we've got everyone back. Thank you. I did have a chance to read the two counselor letters. So it looks like, at least from those letters, that on two different occasions, the child was with a counselor. The counselor felt the child was making progress, and then the mother unilaterally terminated the counseling.
That's
is
accurate,
that
Judge.
correct?
Yes, it is, Judge. That happened, I think that happened on March 17th of this year.
Well, no, wait a minute. Let's get the whole picture. The only reason that the child went to in March of 2021 to see Doug McComas is because CPS set up that appointment and sent the child there because that's a counselor the child had seen over a year ago. And the child went there because dad had made threats against the child. The school saw it on his school computer and reported it to CPS, and CPS got involved because dad threatened to beat the child with a belt for not washing the dishes. So let's be square on that, okay?
Whoa. That's not accurate at all.
Well,
All right. regardless of how the counseling commenced, are you saying that it was not terminated unilaterally by Ms. Hartle?
Mrs. Hartle did not unilaterally terminate it. Both of those counseling ended about a year ago in, I think, May of 2020. So it's been over a year since they had any counseling.
My understanding is that one of the children had a couple of follow-up visits, and I believe it was with Doug McComas, and that was with respect to Austin. And my client believes that there were 2 reports made to CPS by the mother, and CPS did an investigation. There were allegations of abuse. They found no abuse. And Judge, kind of the backdrop on this is that the plaintiff is currently on felony probation for attempting to bribe her daughter with a cell phone, who was the victim of a CSC second that was perpetrated by her then boyfriend, Michael Michael Martone. And so my understanding is that the children were removed from mother back on April 12th of 2019, and then the order entered. They were with my client from then until the order entered in May of 2020. That is the current order of the court.
Well, I don't think those are the facts as far as my client terminating the counseling. The counseling appears by the counselors to have terminated on its own in 2020. My client's the one that set up the counseling for both counselors to begin with, and she advised Mr. Hartle that she was setting up new counseling with the counselor that she's employed now. He's had no objections to it until the first we've heard that he's objecting to it is today. So we assume that he didn't have any problem with her taking the child to a counselor.
Well, we think that the child should continue with counseling with Doug McComas, at least as it relates to Austin. And there's already a relationship also established with Matt, with the other counselor.
So neither child has been regularly in counseling for approximately a year or more.
That would be accurate, Your Honor. Yes, Your Honor.
I mean, is there any disagreement that each child would benefit from counseling?
No, Your Honor.
We've got the child in counseling. We think counseling is important. Yeah.
Who's the current counselor?
Amanda, can you give me the counselor's name?
Her name is Cassandra, and she is with hold on. You there?
Yep.
Okay. She's over on Wildwood. I sent all the information to David when I changed counselors, and he never disagreed. He has never contacted the counselor. I gave him all of the information, and Austin likes his counselor and has been making progress with her and has been seeing her regularly every week. So, and he likes his counselor.
Is that a healing place?
Yeah, it's over on Wildwood across from the Jackson Jackson High. I was looking for her card.
Across from Jackson High is probably Dr. Hand's office.
Yeah, her name is Cassandra. It's healing something.
All right. Well, in any event,
but Austin likes going to her.
When there's joint legal custody, the parents are supposed to agree before a child is enrolled in counseling or a child is withdrawn from counseling, these decisions should not be made unilaterally. On the other hand, if he's making progress with the counselor now, I wouldn't want to interfere with that. But this is not something that either parent should be doing unilaterally. So here's what I'm going to do. I will schedule an evidentiary hearing. I will be focusing on the threshold initially. I'm also going to order that an LGAL be appointed. The parties share the expense for the LGAL. I will let you choose who it is, but I will suggest that both Mr. Kelly and Mr. Hotchkiss both do a very thorough job and provide reports that are helpful to the court. So if you could agree on either one of those, I think, or if you have a third one that you could both agree on, I'm fine with that. I just find their reporting is very thorough and very helpful to the court.
And Judge, when you say Mr. Hotchkiss, are you referring to Ken or Matt?
Ken, yes, Ken.
Okay.
I haven't had a report from Matt yet, so I can't really speak to him.
Okay.
But he's pretty new, so my guess is his dad probably would do a more thorough job only because he's more experienced.
That'll work. Ken's fine with me if that's all right.
That's fine with me.
All right.
All right, and I will find. I'll have Dawn find a date for you.
Okay, and then Judge, in the interim, as it relates to your order that's been in place since May of 2020.
I expect it to be followed.
Thank you, Your Honor.
Okay, thank you.
Thank you. That concludes my matters. Have a good day, Your Honor. Have a good day,
Can I
Dennis.
get one more response, please?
I'll talk to you offline, okay?
This is regarding everything that's been taken from my home since they took the kids.
Okay. You mean as far as
the
property
hearing's
and
over.
the kids?
As far as the
The hearing's over. I'm sorry, Mr. Conant has already logged off.
All
I'm
right,
not going
thank
to
you.
let you put anything else on the record.
All right, that's fine, Judge. I'll talk with you offline.
All right, thank you.
Okay, take notes on these. These will both go in Dawn's box. I've written her a note. And let's see, 9:30. Looks like I got some pre-trials.